Mr. Hartung, what case are you on today?
Mr. Barry's case.
Mr. Van Ettel?
I am on Mr. Barry's case as well, but I have Angel Rosas and Noah Lambert.
Thank you. So if you have a case you're coming into court today on, could you raise your hand? Okay, so Mr. in the back, what is your name? All right. And yeah. And the gentleman in the middle row? Okay. Thank you. Anybody else? Just here to watch. Okay. Mr. Malaro, I do have Gary Bowererman.
Okay, can we take him, Judge? It shouldn't take long.
I can't hear you. I'm sorry.
Can we do him now? He shouldn't take very long.
That's why I said I have Gary Bowererman, if you want to take care of it.
Yes.
I have Mr. Sneed, so I think we have everybody we need. Hi, Mr. Bowererman. Go ahead and unmute your device.
Good morning, Ms. Angelo. Good morning, Mr. Malaro. Good morning,
Good morning. All right, so this is in the matter of the people of the state of Michigan versus Gary Scott Bowererman, file number 25-22277FH. I have Salvatore Malaro appearing on behalf of Mr. Bowererman, and I have Isaac Sneed appearing on behalf of the people today. This is the date and time scheduled for an arraignment in this matter. Mr. Malaro, we received a copy of the prosecutor's request for discovery and witness list.
Judge, we have received the information. We would waive its reading in open court. If we have any defects as time and place of service, we would acknowledge receipt of the witness list. I do not know if we've been served with a request for discovery. Mr. Bowererman would stand mute and ask that the court enter a not guilty plea. Judge, we would ask that a pretrial be set for next week. He has two other matters pending for pretrial that week, next week on the 11th, and he is currently in a rehab facility.
And Mr. Bowererman's going to stay there, right?
Yes, Your Honor. I got this all done. I am, man, thank you.
No trips to Florida.
No, never. I plan to stay right where I'm at, if
Okay.
possible.
All right, so I will enter a plea of not guilty on his behalf. I will set all the matters for pretrial on June 11th. It's arraignment, so my staff will do the notice of hearing. I'm really proud of you, Mr. Bowererman. Stay where you are, and we'll see you back next Wednesday, all right?
I want to thank you guys all for giving this opportunity, and I promise you, my word is bond this time. I am staying, and thank you so much. I'll see you guys next week.
All right, thank you.
Have a good
Bye.
day.
Bye.
Bye-bye.
You too. All right. Dustin Evans not here yet. Let's see what else you have. Right, I don't have a lot of people logging in yet, so hold on. Mr. Malaro. I don't know what this is. Olivia Stebbins Belson, could you unmute your device?
Yes, sorry about that.
Hi, what case are you here on?
I'm here for, do you need the case number or it's for
Yeah,
the
hold on one
Trenton
second.
Berry?
Yes, ma'am.
All right, Ms. Stubbins, Belson, I'm sorry. Hold on one second. All right, I'm
Okay.
sorry. This is Judge Anzalone, and I was wondering if I could see Trenton Berry, John Madison, and Jacinto Rodriguez.
Okay, I understood Barry and then it broke up.
John Madison and Jacinto Rodriguez.
Barry, Madison, and Rodriguez,
Yes, sir.
in that order?
Doesn't matter. But I'll take Berry first. All right?
Yes, ma'am.
Thank you.
You're welcome. Bye.
Okay, I'm sorry, Ms. Stubbins Belson. What case are you here on again?
I'm here for the Trenton Berry case.
Okay, so we're live on YouTube. So are you the attorney?
No, you got her. She's one of the victims represented.
Oh,
No.
got it. Okay, so ma'am, just go ahead and mute your device. And when we're done with the hearing, you can always just log off, all right?
Thank you, Judge.
Thank you. Mr. Malaro, I do have Mr. Winters or Mrs. Winters, but I'm assuming it's him on her device. All right, I have a device that says Jennifer Winters. I'm gonna assume that it's David Winters. And I've sent a request to unmute.
Judge, there's 2 winners on the docket.
Really? Oh, look, we have Jennifer Winters too. And that is Ms. Dumont. All right. Ms. Winters, I'm gonna change your screen name to reflect that Ms. Dumont is your attorney. And she should be here shortly. And when she gets here, I'll bring you back in, okay?
Okay, no problem.
You don't have Mr. Winters with you too, do you?
Yes, I do. He's actually logging in now.
Oh, okay, so he's on a different device?
Yes, we didn't know if we could be on the same device or not.
As long as you don't have no contact, you can.
Oh, no, nothing like that.
Well, why don't you just let me see him then right now on your device?
Okay.
All right, thank you. And I'm gonna send a
problem.
request to start video too.
She said we could be on the same device.
I think you were last time. And who do I have in the jail? Mr. Berry?
Yes.
Okay, good. We'll be with you in just a second. Oh, Mr. Murphy, I didn't realize you were lurking there. You turned your video off and I forget about it. I'm sorry. All right, excellent. So now I have David Winters. Mr. Winters, can you hear me?
I can hear you.
Good. This is in the matter of the people of the state of Michigan versus David Winters, file number 25-22200FH. I have Salvatore Malaro appearing on behalf of Mr. Winters. And I have Isaac Sneed appearing on behalf of the people. This is the date and time set for a pretrial conference in this matter. Mr. Malaro, how would you like to proceed today?
Judge, I was under the impression this was Mr. McCready's case, Mr. Winters, so I was negotiating with the wrong prosecutor. So I would ask to adjourn this, and then we're gonna request a bench conference to see if this matter can get resolved.
All right, my next available pretrial is July 9 at 8:30 in the morning. And Mr. Malaro, can you do the step in order to adjourn? And Mr. Sneed, can you sign your name with permission?
Yes, thank you.
All right, so
That's fine,
Mr.
Judge.
Winters, we'll see you back on July 9 at 8:30 in the morning, same Zoom number. And make sure you reach out to your attorney in advance or return his calls, okay?
I sure will. Thank you.
All right, and Miss Winters, I'm just gonna put the phone in the waiting room now, and as soon as Miss Dumont shows up, I will take your case, all right?
Thank you.
All right, thank you. All right, so now I'm gonna pop you in the waiting room. All right, Trenton Berry. Okay. This is in the matter of the people of the state of Michigan versus Trenton Berry, file number 24-21813 FC. I have Douglas Hartung and Alexander Bayonetto appearing on behalf of the people, and I have Salvatore Malaro and Matthew Murphy appearing on behalf of Mr. Berry. I have a May 13 of 2025 report from the Forensic Center on competency. Has that been admitted for the record?
Yes, not yet.
Okay, Mr. Malaro, you also received this competency report.
Yes, we did, Your Honor.
All right, and Mr. Hartung and well, do you stipulate to entry of this report?
We do, Your Honor.
And Mr. Malaro, do you stipulate to entry of this report?
Yes, we would stipulate to the entry of the report.
All right, so the report is dated May 13 of 2025 regarding competency to stand trial. The back of it. Looks like he was seen by Dr. Edward Rodriguez. Let me get going back here. And the report was submitted by Samantha Baker, licensed psychologist for the Forensic Center. And the findings are that Mr. Berry was an 18-year-old male referred for evaluation regarding competency to stand trial. They reviewed his prior records, school records and mental health issues, showing that Mr. Berry had been compliant with both psychotherapy and psychotropic medication, both prior to and following his arrest, received consistent treatment. There is an intellectual disability, and that is noted and evaluated in the records. During the evaluation interview, Mr. Berry demonstrated the ability to engage appropriately with logical thought processes and fair insight. His speech was linear and relevant throughout the interview. He knew who he was, where he was, the exact date, and understood the purpose of the interview. He appeared to be a low average intelligence. His emotional expression was relatively unremarkable. He was polite and cooperative with the interview and denied any current thoughts of suicide or self-harm. Mr. Berry was aware of the underlying allegations against him. He demonstrated an understanding of his current charges and the associated maximum penalties. He demonstrated capacity to discuss the allegations against him in an organized manner. He spoke at length about the roles of various persons and roles related to resolution in this case, including judge, defense attorney, prosecuting attorney, witnesses, defendant, and jury. He understood the implications and definitions of various pleas, including guilty, not guilty, no contest, and not guilty by reason of insanity, either following education or prior to receipt of such education. He understood the concepts of plea bargain and a trial and discussed these contents in the context of his current charges. He recognized the utility of working with his defense attorney despite his expressed concerns. He expressed a desire for a positive outcome, which to his case, which demonstrated self-interest and flexibility. And they end with, while I acknowledge that the ultimate decision in this matter rests upon a judicial determination, in response to the request of the court, it is my opinion that Mr. Berry was competent, is competent, and was competent to stand trial at the time of the evaluation. That is to say, he was capable of understanding the nature and object of the proceedings against him, as well as assisting rationally in his own defense. Anything to add, Mr. Hartung?
No, Your Honor, thank you.
Anything to add, Mr. Malaro?
No, Your Honor.
So I do have a finding in order on competency. I'm going to make a couple copies because I think they need like 5 originals. So we will make those copies. The court will find that the defendant is competent to stand trial. The case shall continue to the next stage of the criminal process. And at this time, are the parties requesting a pretrial date?
Judge, we'd request a trial date.
Okay. So, Ms. Adams, I'll put that finding in order on top of the report, and then I'll just need 4 copies.
Okay.
And, Ms. Adams, would it be possible to get the book? Oh, thank you. No, everybody. Take this. And bring this. Yeah. All right, hold on 1 second. Mr. Malaro, how many days do you think you need for trial?
I expect the defense to put on 2 to 3 days worth of testimony.
Mr. Hartung?
This was originally set for 2 full weeks of trial, including Monday,
Okay,
back when we had originally set for trial.
okay, so. One second. Miss Adams, what does Monday, September 29th look like in the morning? Or, I'm sorry, yeah, September 29th.
Judge, I'm not available that week.
Okay. Thank you. All right, I have Monday, October 6th.
That's no good. That whole section's no good for me, Your Honor. I'm sorry.
Guys are like divorce attorneys. I can never schedule them. Now, for the record, our Mondays are scheduled out like 4 months, and there'll be 40 cases scheduled on a Monday. So the best, you know,
Yeah, I mean, do we have to start on Monday, Mr. Hartung?
We don't have to. You just said it that way before to get it through the 2 full weeks.
right. So we're not available September 30th that week, right, Mr. Malaro?
Yeah, I'll be out of the office that week.
You're not available October 7th.
That whole middle chunk of October is bad for me. End of October, 1st November would probably be better from my standpoint.
That's where I'm ending up. I'm sorry. So we're closed November 11th for Veterans Day. So we have a closure on that day. But if I go back to November 3rd, we would have, I could start a Monday trial date, but understanding we're closed for Veterans Day.
That's
So,
fine with us.
okay, so trial date starting November 3rd, November 3rd, hold on. Well, let's see here, November 3rd. No, because family law, no. When is family law institute? Oh, that would work. So 2 weeks starting November 3rd, Mr. Malaro?
Yeah, that's fine. That'd be perfect, actually.
Mr. Benetto?
Yes, sir.
And Mr. Murphy?
Yes, that works for myself. Thank you, Your Honor.
All right, so the November 3rd of 25 at 9 a.m. Obviously, our trials start at 9 a.m. Except for Wednesdays, we start at 10:30 a.m. I'm going to, are you here October 24th, Mr. Hartung?
I'm sorry,
Are you in town October 24th?
I'm not all here by Zoom.
Well, I would like a day to sit down and do jury instructions with both of you, like have them submitted and then all of us sit down and finalize them before the trial. But I could do,
The 24th should be fine.
I could do Halloween, October
That's fine too.
31st. Mr. Malaro, are you available October 31?
Yeah, says I am.
All right, so I'm gonna set final pretrial for October 31. It's a Friday, so that's not my typical time at 8 a.m. And that'll be in person, so we can sit down and go through the already submitted jury instructions, because I'm going to require them to be submitted by October 24.
Your Honor, we already submitted ours quite some time ago.
Good.
And board year and witness list.
Okay, just in case there's any changes, I'll put another date on there, because that'll give you both an opportunity to make any changes if you need to. And I'll make that the final motion date too, on that Friday morning.
Is that filed in Erd, Your Honor?
Always, yep. Let's see, today is June 4, 5. All right, so I have a scheduling order. Trial will begin November 3rd of 2025 at 9 a.m. It's scheduled for 9 days, but obviously jury deliberations can go into the next week. Motion deadline filed and heard, and motion and limine deadline October 31. Obviously, you guys have had plenty of time. Any amended jury instructions or any jury instructions due October 24 of 25, as well as voir dire questions. There will be a final pretrial conference in person on Friday, October 31 at 8 a.m. Do you want Mr. Barry brought in person as well, Mr. Malaro?
For the final pretrial?
Yes, sir. I mean, you're
Sure,
gonna be
yeah,
in person. Okay, so I'll put that in twice in person, so maybe. All right, I have finished the scheduling order and we will get copies out to everybody. Is there anything else we need to address?
I have one thing. We don't have the witness list for the defense. It was scheduled to be delivered to us on February 12th. We had a bench conference in this court on February 11th. They said they had, at that time, they said they had their witness list prepared. They told us they would get it to us. They never have. On May 7th, I texted Mr. Malaro and said, I'd like to have your witness list so we can get our investigators to, interview anybody as necessary. And he said he would. Still haven't got it. It's been 28 days later now. Still don't have the witness list. It's kind of become a practice by the public defender's office not to give the prosecutors the witness list. And I don't understand why the courts continue to put up with that, because the court has issued an order. They have been required to do this. They don't follow these rules consistently as it relates to murder cases. I recall one recent case where I got the witness list 18 hours before the trial was set to start. And I guess the court felt that there was nothing they could do about it at that point in time. We don't want to risk an ineffective assistance of counsel argument, but we're all officers of the court here. And I think it's incumbent upon all of us to follow the court's rules.
Deadline of June 20th.
Fine.
Mr. Malaro, you can provide that by June 20th.
Sure. But to respond,
right.
Judge, I think I deserve to respond to that.
You can.
Likewise, our office gets reports, witness lists, amended witness lists, right up to the moment of trial. I don't think there's the insinuation here I resent, and Mr. Hartung knows better. There was a competency evaluation. Until we knew what that was, there's no point in doing this extra work on this matter. So it goes both ways.
You told me you had it already done and prepared.
All right. Thank you, gentlemen. We will see you back on October 31st for a final pretrial settlement conference. Thank you.
Thank you, Your Honor.
Ms. Dumont,
Judge.
I have Ms. Winters. Let me take her real quick. All right, Ms. Winters, go ahead and start your video, please. Thank you. Go ahead and unmute your device, Ms. Winters. Thank you. This is in the matter of the people of the state of Michigan versus Jennifer LaShawn Winters, file number 25-22201FH. I have Isaac Sneed appearing on behalf of the people and Katerina Dumont appearing on behalf of Ms. Winters. Says the date and time scheduled for a pretrial conference. Ms. Dumont, just for your information, Mr. Malaro adjourned Mr. Winters for a pretrial on July 9 at 8:30 in the morning. How would you like to proceed today?
Your Honor, this is a global plea resolution between Mr. and Mrs. Winters, so we would just like to follow along with Mr. Winters' case. We are at the mercy of their plea to get ours dismissed.
All right, so I will adjourn this as well through July 9 at 8:30 in the morning. And can you do the step in order to adjourn?
Yes, Your Honor.
All right, thank you, Ms. Winters. You have a good day.
Thank you, you too.
Cleared out my courtroom, Mr. Hartung. All right, let's see. I have. Hold on, Mr. Madison, I'll be right with you.
Okay.
Mr. Glazier's not here. Okay. Let's see what this is. Brian Fry, I have Britney Bour. Let me bring her in. All right, this is in the matter of the people of the state of Michigan versus Britney Bour, FOOR, file number 24-21993FH. I have Isaac Sneed appearing on behalf of the people and Brian Fry appearing on behalf of Ms. Bour. Mr. Fry, how would you like to proceed on pretrial today?
Yes, Your Honor, I believe we have a resolution. We have submitted a signed plea agreement to the court. Ms. Bour would plead guilty to count 5, larceny in a building. All remaining counts would be dismissed, and there would be no habitual offender supplements. I don't think there is anyway, but there wouldn't be.
All right, any sentencing agreement or anything of that nature?
No, Your Honor.
Okay. Mr. Sneed, is that a correct recitation of the plea?
Yes, it is. Thank you, Your Honor.
Okay. Okay, I have somebody on a Samsung device. I'm going to send you a request to unmute your device. Can I ask what your name is, please?
Daniel Party.
Spell your last name.
P-A-R-D-E-E,
P-A-R-D-E-E, just like the singer? Okay.
Yes, ma'am.
Okay, and your attorney is Michael Dagger Margosian. So you're gonna bear with us because I actually think I have him in the room, and so just be a moment. Let me check this other one, 'cause sometimes it's pretty late. Mr. McCready, which case are you coming in on?
I'm on Dustin Evans.
Okay, and Lance Horde and Corey.
That's my cases, Judge. They're co-defendants.
Okay, I'm gonna put them in the waiting room real quick. I'll be right with you in a minute. Okay, so Mr. Sneed, regarding Britney Bour, the plea agreement is to plead guilty to count 5 with no subs. I know there's a plea agreement form. It just hasn't made it to my file. You guys are really good about that. And there's no sentencing agreement. The other counts would be dismissed and no subs. Is that a correct recitation of the plea?
Yes, it is.
All right, Ms. Ford, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, can you state your full name for the record?
Britney Bour?
All right, so Ms. Bour, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 5, let me get back there, larceny in a building, which carries a maximum penalty of up to 4 years in prison and or a $5,000 fine?
Yes.
Now, are you satisfied with your attorney and the advice that he's given you?
Yes.
You and neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct? Mr. Sneed?
Yes, it is, Your Honor.
Is that correct, Mr. Fry?
Yes, that's correct, Your Honor.
And Ms. Bour, as far as you're aware, is that correct?
Yes.
All right. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Ms. Ford?
Yes.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
Ms. Ford, if you have not already received it, we have an advice of rights form. We need her to sign, Mr. Fry. Do you want to have her sign that with you, or do you want us to mail it to her to get returned?
I can get her to sign it, Your Honor.
Okay, we will, if you have one, you can do it, or we'll email it out to you, all right? It's just a standard scale form, so, but we are required to do those now.
I forgot about that, Your Honor. I'll get her to sign it, though.
We're getting used to it. So, ma'am, so we had some changes in the law. So do you understand if your plea is accepted and you engage in any misconduct defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms or conditions on bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with the order of a court pending sentence. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from the admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you, Ms. Ford?
No.
All right, so Ms. Bour, how do you wish to plead to the charge that on about August 12 of 2023 in Madison Township in the county of Lenawee that you did commit the offense of larceny in a building?
Guilty.
All right. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea?
No.
Okay, do you want me to repeat that?
Yeah, sorry.
Okay, so do you understand if I accept your plea, you'll give up any claims that your plea was given as a result of promises or threats that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea? So you can't come back later and say, I didn't want a plea or I was forced to do it, all right?
Yes.
Okay, as a prosecutor or defense counsel, we have any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty, Mr. Sneed
No, Your Honor.
and Mr. Fry?
No, Your Honor.
Has your attorney promised you any particular sentence or estimated what your sentence will be? Like, did he guarantee you a jail term or no jail term or anything like that?
No.
Is it your own choice to plead guilty?
Yes.
All right, so ma'am, on August 12 of 2023, were you in Madison Township in the county of Lenawee?
Yes.
All right, and you were working or visiting a nursing home?
Yes.
Which one was it?
Hampton Manor?
Okay, and at that time, you were working there?
Yes.
All right, and you had access to somebody's identification cards or money or checks, is that correct?
Identification, yes.
Yep. Was it a patient there or an employee there?
A patient?
Okay, and you took that item?
Yes.
Okay, and did you take some checks too?
No.
Okay. All right, Mr. Sneed?
Your Honor, we're satisfied with the fact she'll admit to taking identification.
All right, and you had no right to take that, correct, Ms. Ford?
No.
All right, has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, Your Honor.
Mr. Fry?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. I'm going to set this for sentencing on July 18. Are you available that day, Mr. Fry?
Yes, Your Honor.
All right, July 18 of 2025 at 8:15 in the morning. I'm going to ask that be in person. That doesn't mean anything, Mr. Fry, but I am asking for it to be in person. So, Ms. Bour, I'm going to put you in a breakout room with Mr. Jones from the Michigan Department of Corrections. He's going to give you some instructions, how to meet with them, how to complete an evaluation and the paperwork they need. You're going to have to come and meet with them in person, which is fine because you live local. And then they'll prepare a pre-sentence report. When you meet with them, be truthful about your background and the events that occurred. They'll put it in a report. We'll provide a copy to Mr. Fry. Mr. Fry, make sure you call him in before sentencing and review it with them. And Is there any restitution, Mr. Steen or Mr. Fry?
There is restitution. That's part of the plea agreement, that it would be paid by the defendant as ordered by the court. So
how much is
presume there'll be an
restitution?
amount included in the PSI.
Okay, so we don't know how much. Okay. I think I have 95, 65. Is it that minimal amount?
Your Honor, I would have to review the police report again.
All right, so Mr. Fry, do you wish to go in the breakout room with her?
Sure, Your Honor.
Okay, so I'm going to open up a breakout room, Ms. Bour, and you're going to go in there, your attorney and Mr. Jones. Mr. Jones will get your contact information and make sure you show up for those appointments. So Brian Fry, Britney Bour, and Ms. Jones, go ahead and join that breakout room. Oh, yeah, I do. I have one. All right. Okay. Thank you. Joanne Spade. You have a new file. Okay. Okay. All right. So let's reorganize. Mr. Madison.
Yes, ma'am.
I know. Hold on one second. All right. This is in the matter of the people of the state of Michigan versus John Madison. We have two files, 23-2.
That's Brandon Madison.
Oh, wait. Well, I asked for John Madison, but do I have Brandon Madison too? No, yes, no, hold on. MN. No, Judge, you don't. I don't. They gave me the wrong medicine. It's good to see you though, but will
Hey,
you
how
tell
you
them I
doing?
need, will you tell them I need the other one?
Okay.
All right, have a good day.
Yeah.
All right, moving on. All right, so I have another gentleman in the jail. What's your name, sir?
Rodriguez,
What's your name?
me,
Yeah.
Jacinto Rodriguez,
Okay, thank you, Mr. Rodriguez. Hold on one second. What's your name now?
Gerald overall,
Spell your last name?
OOVERALL.
What's your first name?
Gerald.
Gerald. Are you just here to watch?
No, I'm here, they said something about, they sent a jury duty letter to a mail, some mailbox.
Oh, all right. So did you go to the clerk's office?
No.
All right. So I'm gonna send you down to the clerk's office and to ask for Phyllis because she does our jury questionnaires and she'll take care of you down there, all right?
Okay, thank you.
Thank you, Mr. Overall. All right, so that's round one. This is Mr. Rodriguez. All right, so get your file, Mr. Rodriguez.
thank you.
Okay, this is in the matter of the people of the state of Michigan versus Jacinto Rodriguez, file number 25-22282AX. So hold on a second, because this is an extradition. So, Mr. Rodriguez, we are here today on a proceeding to determine whether you wish to waive your right to extradition.
Yes, ma'am.
Extradition is a proceeding to return you to another state in which a warrant has been issued for your arrest for the commission of a felony. It is in effect a demand by another state for your surrender and to return to that state to face the crime with which you are charged. So you are charged by Sandusky County, Ohio, on a pending arrest warrant charging the crime of felony 5 possession of drugs, which is a felony in the state of Ohio. We cannot, in this court in the state of Michigan, determine the truth or the falsity of the charges made against you in the state of Ohio. You do not have to waive your right to extradition. You can require that the governor of the state of Ohio make demand upon the governor of Michigan for a warrant for extradition. You have the right to demand and procure legal counsel. If you cannot afford an attorney, we will appoint one for you at county expense. If you or your attorney wish to test the legality of your arrest, you may apply within a reasonable time for a writ of habeas corpus. That is a writ by which your custodian is required to bring you before the court for the purpose of having a hearing to determine the legality of your arrest. Do you understand the rights that I've just told you, sir?
Yes, ma'am.
Would you like a court-appointed attorney at this time?
No.
Okay.
No.
Do you want to waive your right to extradition to a writ of habeas corpus and to an attorney and go voluntarily to the state of Ohio to face the charges made against you in that state?
Yes, ma'am.
All right. Did they give you the forms to sign?
I have nothing.
Okay. Will you tell them you need the extradition forms to sign? I know we already sent them over there. So
Okay.
I got to have you sign them and swear you in. So I don't, hold on. We're there.
Good morning, Your Honor.
Hey, so this is Judge Anslone. Mr. Rodriguez needs his extradition forms.
Yes, ma'am, we'll get them to him.
Awesome, thank you.
No, person.
So they're gonna bring the forms to you and I'm gonna have you sign them and then I'll swear you in and make sure you sign them of your own free will, all right?
Okay. So what exactly happens at this point?
Okay, so if they have not, they put me on hold at the jail, that's fun. So if they don't pick you up within 14 days, I'll bring you back into court, okay?
Okay.
Isn't Ohio pretty good about?
Yes.
Ohio is pretty good because they're kind of close, so they pick up pretty fast.
Okay.
Okay,
Then, so I get there, they arraign me and then give me a bond or something?
I don't know what Ohio does.
Okay. Okay.
No, so I'm assuming you'll just go through your court process and Depending on your past history and the charges you're facing, they'll either give you a PR bond or a cap, whatever they do.
Okay.
All right, so give us a minute while we're waiting for those. Mr. Noe, I know you're here, but I have a couple other people that were here in front of you, so I'm sorry.
No, I understand. Thank you. You can't get rid of me, Judge.
You're here all day long. Mr.
Yeah.
Dagger Margosian, did we finish Mr. Party?
No, Your Honor.
Is he there? Where'd he go? There he
he's
is.
there.
Okay. I lost him. I couldn't see him. All right. Grab his file. So, in the matter of the people of the state of Michigan versus Daniel Benjamin Party, file number 25-22258FH. I have Michael Dagger Margosian appearing on behalf of Mr. Party, and I have Isaac Sneed appearing on behalf of the people. This is a date and time set for a pretrial conference in this matter. Mr. Dagger Margosian, how would you like to proceed?
Your Honor, Mr. Party is going to be pleading guilty as charged, no subs, no objection to no upfront jail. And at sentencing, I'll be asking for a probation transfer. He lives in Mecosta.
All right, slow down, Mr. Dagger Margosian. So he's pleading guilty as charged with no subs. There's an agreement between the prosecutor's office and your office that there'll be no upfront jail.
Correct.
And I don't have control over the transfer. That's MDOC, but if he lives out of county, we'll automatically do that anyway. So he will have to report to the probation department here a couple times before that. All right.
Yep.
Okay, Mr. Sneed, is that a correct recitation of the plea?
Yes, it is, Your Honor.
All right, Mr. Rodriguez, did you get your forms yet?
No, ma'am.
All right, no, they're on their way. All right,
Okay.
Mr. Party, do you pronounce it Pardee or Party?
Party.
Just like, all right, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, so, Mr. Party, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty? Hold on, let me get to the felony information as charged, and there's no subs, Mr. Dagger Margosian? Right?
There are, but those are being dismissed.
Yeah, okay. So, Mr. Party, is it your intention then today to plead guilty to count 1, controlled substance possession of methamphetamine, which carries a maximum penalty of up to 10 years in prison and or a $50,000 fine?
Yes, Your Honor.
All right, are you satisfied with Mr. Dagger Margosian as your attorney and the advice that he has given you?
Yes, Your Honor.
Other than the agreement that there would be no upfront jail, neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Sneed?
Yes, Your Honor.
Mr. Dagger Margosian?
Yes, Your Honor.
And Mr. Party, is that correct?
Yes, Your Honor.
Right, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Party?
Yes, I do, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right?
Yes, Your Honor.
All right, Mr. Party, are you still living in Remus, Michigan?
Yes, I am.
Is your house number 560?
Yep.
Right, we are going to be mailing to you an advice of rights form, and in that envelope will also be a self-addressed stamped envelope for us. There'll probably be 2 copies in there. I need you to sign that advice of rights and put it back in the envelope that's already self-addressed and stamped with my name on it, and mail a copy back to me by putting it in your mailbox or at the post office, okay?
Okay.
All right, so, and do you understand if that plea is accepted, if this plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms on conditions of bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. So you're out on bond. So if you commit a new offense or you violate bond conditions, understand I'm not going to be, I'm not going to have to honor the sentencing agreement, and I could give you jail. Do you understand that?
Yes, I do, Your Honor.
Okay. If you are not a U.S. citizen, if you're not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've just given to you?
No, Your Honor.
All right. How do you plead to the charge that on or about August 30 of 2024 in Madison Township in the county of Lenawee that you did commit the offense of controlled substance possession of methamphetamine? Guilty or not guilty?
Guilty.
All right. Mr. Rodriguez, did they bring you the forms yet?
No,
They'll
ma'am.
get them. Don't worry. They'll get them. All right. Has anyone, Mr. Party, made any threats or promises to you to induce you to plead guilty to this charge? I think I already asked you, but I'm asking you again.
No, Your Honor.
All right. Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, I do.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Sneed?
No, Your Honor.
Mr. Party? I'm sorry, Mr. Dagger Margosian as well?
No, Your Honor, thank you.
Okay. Has your attorney promised you any particular sentence or estimate what your sentence will be other than the no upfront jail?
No, Your Honor.
All right, and it's your own choice to plead guilty?
Yes.
So, Mr. Party, on August 30 of 2024, were you in Madison Township in the county of Lenawee?
Yes.
And did you have in your possession methamphetamine?
Yes.
Did you know it was methamphetamine?
Yes.
Did you have any legal right to possess it?
No.
Are the people satisfied, Mr. Sneed?
Yes, Your Honor. Thank you.
All right, has the court complied with MCR 6.302 B, C, and D? Mr. Sneed?
Yes, Your Honor.
Mr. Dagger Margosian?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I am going to refer this matter to the probation department for a pre-sentence investigation. Mr. Dagger Margosian, are you available July 18 at 8:30 in the morning? 8:15 in the morning.
Yes, I am. Thank you.
All right. So, Mr. Party, I'm going to set this for sentencing on July 18 at 8:30 or 8:15 in the morning. I'm going to set that via Zoom because there is an agreement to no upfront jail, and I know where Mecosta County is, and so that's a little bit of a drive. I'm going to put you, yeah, but you're still going to have to make one trip here because you're going to have to do your pre-sentence report. And so, Mr. Jones yep, where'd Mr. Jones go? So I'm going to put you in a breakout room with Chris Jones from the Michigan Department of Corrections, and he's going to give you some instructions. When you meet with them, be truthful about your background, be truthful with them about the events that occurred, and they will prepare a pre-sentence report. Make sure you reach out to Mr. Dagger Margosian in advance. He's really good about it. and review that before the day of court. You can't appear via Zoom because of the plea agreement. But understand if you violate or you commit any new crimes, I can change that to in person. All right, so we will see you back on that day, and your bond's continued. I'm gonna open up a breakout room with Mr. Jones from MDOC, and I'll give you some instructions, okay?
Yep, thank you.
Thank you. Okay. Okay, so. Miss Adams, can you verify whether or not a waiver of arraignment was done? Maybe that we don't have on Yesenia Hernandez, because I don't have an attorney on her yet. Or,
I don't have one, but I'll check with the clerk's office.
okay. All right, so everybody, Mr. Laurel.
Hello,
Hey, so I am also ready on Noah Lamley.
Ted Lamley.
Yes, sir. And then I asked for the wrong Madison, maybe. I needed John Madison.
Yeah, so John Madison actually isn't here.
Oh,
Yeah. So just Lamley then?
yeah, all right. John Madison was on your jail list, that's why.
Gotcha.
Okay, thank you.
All right, we'll get Lamley around.
All right, bye.
Bye.
I don't see John Madison, so, okay. All right, Dustin,
Yes, ma'am.
Dustin, yeah, let me find you on my sheet. I have you here, and your attorney's here, so, give me just a second. Dustin Evans, Mr. Malaro, are you ready on Mr. Evans?
I think we are.
Okay, so this is in the matter of the people of the state of Michigan versus Dustin Lee Evans, file number 25-22262FH. I have Salvatore Malaro appearing on behalf of Mr. Evans. And this is the date and time scheduled for a first pretrial conference in this matter. I have Dave McCready appearing on behalf of the people. So, Mr. Malaro, how would you like to proceed?
Your Honor, been discussing this matter with.
I can't hear you. I'm sorry. Give your mic a minute to catch up. Try again.
How about now? Can you hear me now?
Yep, perfect, perfect.
So we're going to ask to adjourn this, Your Honor. Mr. McCready and I have been trying to find a resolution. I think we're almost there. There's also a PPO scheduled at 10 this morning.
Yes,
that
sir.
We're not on. I would ask, although I'm not representing Mr. Evans on that at the moment, that we adjourn that as well, as it's out of the same incident.
Mr. McCready, any objection?
I spoke with Mrs. Evans this morning, and that's fine from our side. I'd like to resolve them both at the same time.
Okay. All right, so I'm going to set this for a pretrial on July 9. And Mr. Malaro, can you do the stipend order to adjourn? That'll be July 9 at 8:30. And Mr. McCready, can you sign your name with permission?
That's fine. And the PPO hearing will follow that?
Yep, I'll set it over to the same day and we do the notice on that.
Okay.
Your Honor, if I may.
Yes, sir.
Mr. McCready, does the July 9th, does that work in your timeline? I know we talked an earlier date.
That's my next available on a Wednesday.
That's fine with me.
Okay, all right. Okay.
Okay, I will set them both over to 8:30 on July 9th.
All right, thank you,
Thank you both. Mr. Evans, you're all set. Yay, Mr. Rodriguez. Okay.
Do I sign,
So
do I sign every
So
last one?
You do, right in the center. You'll have to date it. It's June 4 and then sign each one.
Thank you,
While
ma'am.
you're doing that, in the matter of the people of the state of Michigan versus John Carl Lorenzo Madison, two files, 23-21575FH, 23-21625FH. Today is the date and time set for request and summons for probation violation on each of these files. He was released to attend a treatment program and failed to go. So I'm going to issue a bench warrant for his arrest on each file, and I will set bond in the amount of $25,000 cash on each file. All right, Mr. Rodriguez, did you sign them?
Yes, ma'am.
All right, let me get back to my extradition scripts. So hold on. Want to raise your right hand? Do you solemnly swear that the signing of those papers is your free act and deed for the purpose of waiving extradition?
Yes, ma'am.
All right, Mr. Rodriguez, I wish you the best of luck. They'll get those over. I'll sign them, and they'll reach out to Ohio, all right?
And you said they're pretty quick, right?
Usually Ohio's pretty fast because it's next door, right? So.
Yep. I just want to get this over with. So I appreciate it. Thank you so much.
All right, go Bucks, right? Welcome to Ohio.
All right, thank you.
I'm a Michigan State grad, so I didn't really know that.
Okay, how do I get out of here?
Just kind of knock on it, I think, and they'll let you out. Huh? Or does the door open? No, they lock them.
That's how you know I haven't been here.
The door handle should work.
I got it. Have a good one.
Yay. All right.
Thank you.
Okay. So I do not have John Glazer yet. I know a few of you are here for John Glazer. I do not have Rhonda Underwood yet. Hold on. You're almost next, Mr. Noe. Don't have Noah. Oh, who do I have at the jail?
Noah Lamley?
Oh, okay. I gotta get Mr. Murphy out of here so he can go to Judge Olsaver's court. Judge Olsaver is scarier than I am, so. All right, in the matter of the people of the state of Michigan versus Noah Lamley, file number 24-22063FH, 25-22205FH. I have Matt Murphy appearing on behalf of Mr. Lamley and Alexander Bayonetto appearing on behalf of the people. This is the date and time set for pretrial on both files and a show cause on the 24 file. So, Mr. Murphy, how would you like to proceed today?
Your Honor, we got a letter from the Forensic Center dated May 8th. It was filed in our file on later in May, but it was dated May 8th. I don't know if the court received that.
So I did receive a letter dated May 8th from Lisa Anaker, psychiatrist from the State of Michigan Department of Health and Human Services Center for Forensic Psychiatry with a status report on April 14th, he failed to appear, but then he was seen for evaluation on criminal responsibility on May 2nd. It's in progress and we have not received it yet. So we need to adjourn today's court date. So how far out? I'm thinking 30 days, but if we get it, we can get you in sooner.
Yes, Your Honor. Thank you.
All right, so I'm gonna set this out to July 16 at 8:30 a.m. Obviously, Mr. Murphy, if that report comes on in earlier, and for whatever reason you and Mr. Bayonetto have reached an agreement, Mr. Lamley is comfortable with, I'll get you in sooner on a day, not a Wednesday, okay?
Yes, Your Honor. Thank you.
All right, Mr. Lamley, I'll see you back on July 16. Thank you.
Mr. Lamley, I'll Zoom with you soon, okay?
Okay.
Your Honor,
anybody in here have Matt Murphy as an attorney? No?
Your Honor, should my office do a stipend order for that date and time on Mr. Lamley? I'm sorry.
Yes, thank you.
That's all that I had, Your Honor, for this morning. Thank you.
All right, thank you. She's going to her attorney's. No, probably attorney. I want to go sick too. Okay. All right. So, Mr. I think Mr. Noe, you're up. Hold on.
Judge, may I leave your court?
Do you have anything else?
I don't show anything.
Okay, then you're free to leave. Thank you.
Thank you, Your Honor.
All right, so Mr. Noe, I am ready on yours. I got your other file. Walworth. All right, and are your clients in your waiting room, Mr. Noe?
Judge, I had my clients, they were on this device and my device, as technology often does, decided to restart on me, just as you called the case. So, regardless, Judge, they're with me. What I'd like to do on this matter.
All right, so hold on, let me call the case. All right, we are here in two matters. The original file that was assigned to me was people of the state of Michigan versus Corey Thomas Walworth, file number 25-22228FH. My prosecutor is Isaac Sneed and Charles Noe is the attorney for Mr. Walworth. I've just been handed the file in the matter of the people of the state of Michigan versus Lance Aaron Horde, file number 25-22229FH. Once again, I have Charles Noe appearing on behalf of Lance Horde and Isaac Sneed appearing on behalf of the people. The note I have states that parties requested to be transferred to Judge Anslom for a plea together with co-defendant who is assigned to her. So, Mr. Sneed, there was no objection to that file being transferred to me?
No, thank you.
And Mr. Noe, no objection to that file being transferred to me?
None.
All right, so while you hook your computer up for your clients, because I don't have them.
Yeah, they're here, Judge, if you want to see them.
But I'll give you a minute to start that other computer, because if you want.
No, Judge, I think in this matter, our intention was to enter the plea. There's been an issue with the plea that I wanted to address with Miss McClure. The prosecutor is actually handling the case. So on this matter, I'd like to, the original intention was to enter a plea, and that still may happen.
Okay.
We're hoping you to set this matter for one more pre-trial in a few weeks, so I can discuss that with her.
My next available is July 16 at 8:30 in the morning, so we can set it over to there. Obviously, Mr. Noe, just for your schedule's sake, if a plea agreement is reached, if you guys reach an agreement that's satisfactory, I will sneak you in on any other day than a Wednesday. All right.
That works. Thank you. And I will.
All right. And Mr. Noe, can you do the stip in order to adjourn for both files?
That'd be my pleasure. Mr. Sneed, may I send that with your permission, please?
Yes, please.
He was never logged in. No. So, Yesenia?
Yeah.
We're just waiting for your attorney, okay?
Yeah, he said he was trying to log on, but it wasn't letting him, so.
But he's not been logged in, so as soon as he logs in, we'll take you, all right?
Yeah.
All right, and Mr. Noe, you're gonna do the stip in order to adjourn for both files, and you're gonna have to do a stip in order or whatever to send the file to me. I think that's how you do that. I'm not sure. All right?
That's fine. That's fine. Thank you.
Thank you, Mr. Noe. Okay, Mr. Avila, why don't you come up to the podium? Mr. Glazier just zoomed in. So he goes to, we divide the attorneys up, so he goes to another court first. So, all right, in the matter of, you can move that mic if you want. In the matter of the people of the state of Michigan versus Tomas Angel Avila, file number 25-22279FH. I have John Glazier appearing on behalf of Mr. Avila, and I have Isaac Sneed appearing on behalf of the people. This is the date time set for arraignment in this matter. Mr. Glazier, have you received a copy of the prosecutor's request for discovery and witness list?
Yes, Your Honor.
And do you waive the reading of the felony information?
Yes, we waive that, Your Honor.
Okay, and how would you like to proceed today?
Your Honor, we're going to enter a plea not guilty, ask the matter be set for pretrial.
Okay, my next available pretrial is July 16. Ms. Adams, I'm going to need a notice for Mr. Avila. Are you available July 16, Mr. Glazier?
Hold on a second. Yeah, I'm available.
All right, so July 16 at 8:30 for arraignment or for pretrial. And Mr. Avila, if you want to have a seat right behind you on that bench, we will get you a copy of a notice of hearing. All right. All right. Thank you, Mr. Avila. All right, I will enter a plea of not guilty and bonds continued on that one, Mr. Glazier. So let's keep going. Gregory Bowers, you want to come on up? All right, this is in the matter of the people of the state of Michigan versus Gregory Allen Bowers, file number 25-22231FH. I have John Glazier appearing on behalf of Mr. Bowers and Isaac Sneed appearing on behalf of the people. This is the date and time set for a pretrial conference. In this matter, it's a first pretrial. So, Mr. Glazier, how would you like to proceed today?
Your Honor, I'd like to set this for a second pretrial, not too far away.
All right, my next available is July 16, Ms. Adams. I'm going to have you do a notice of hearing for Mr. Bowers on this one as well. So July 16 at 8:30 in the morning. Are you available that day, Mr. Glazier?
Yes, I am here.
All right, so Mr. Bowers, you can appear in person or you can appear via Zoom. Do you have Zoom instructions?
I'll just show it. Yeah.
Okay, and Mr. Avila, do you want Zoom instructions?
Sure.
Okay, so my bailiff's gonna hand you both Zoom instructions just for fun, but have a seat behind you and we'll get you a notice of hearing for July 16 at 8:30 in the morning. All right, let's see here. That one's gone. Okay.
Is Isaac still there?
Yes, right next to you. He's sitting right next to you on my screen.
Okay. Isaac, is this still your case, Bowers?
No, it's not. I believe Mr. Gumto is handling it.
Okay. All right. Thanks.
All right. So, Mr. Glazier, I don't believe that I have anything else with you.
Okay. I'm all set, Your Honor.
Thank you.
Come in and see me, Mr. Bowers.
Okay.
You can come in to see me also, Mr. Avila.
So, Rhonda poked her head in. I'm ready for her if she's ready for me. All right. Thank you, Mr. Glazier. I believe you're all set.
All right. Thank you, honey.
Your attorney, I do not have him in the waiting room yet.
Something about the 12 and 3rd, and he'll be on at 10.
Well, I won't be here at 10, so court starts at 8:30. Yeah, I mean, I might be here at 10, but I have other stuff, so.
I just let him know.
Tell him it'll only take 5 minutes.
That's exactly what I told him. I gotta get to work. I've been told him to get on there.
Oh, I thought you were going to the zoo today.
No, so that's not what this is for?
Huh?
That's what this is for, the zoo? No, I never ended up going to the zoo because I couldn't go. So I thought this was just my arraignment for my.
It is, it's an arraignment, which is why I thought they filed a. Okay, all right, so give us just a minute. As soon as he logs in, we will get you moving, all right?
Thank you.
Step off the bench for a minute. Ms. Spade and Senora Spade, you need to as well. Thank you, Judge.
I'm not sure which. Hi, how are you? Good, how are you? Good, thank you. Good to see you.
Do you guys know the Zoom code? Or can I go with the Zoom code?
I have a sheet. Okay. Just a second. Sorry. Thank you.
No.
Take care.
I thought you retired, Joanne.
No, I'm still here.
She just moved up in the world.
Yeah, like that, I just moved back up. This is where I'm starting. Yeah, I'm still here, still enjoying it. Yeah, let me see. long as my health is good. Yeah. That's what matters. Yeah, exactly. Good to see you. You too. I don't want to. Like, look, I could have been out of here. I know. Because they asked me to do, they called and asked what to do, but if she'll allow me to go, I want to go to the jail. This is really. That's not one, that's just in case when she comes in, he says he's on.
Please rise for court's now in session. You're on this signing in.
He's coming up. All right. Right, Manny Kavajian, correct?
Good morning, Your Honor.
Good morning. So this is in the matter of the people of the state of Michigan versus Yesenia Hernandez, file number 25-22280FH. She is represented by, and tell me I'm pronouncing this right, Manny Kavajian. Did I pronounce it? How do you pronounce it?
Mani. You got the last name correct, Judge. That's the hard part, but the first name's Mani.
That's because I know so many Armenians. All
I'm
right.
Persian, Your Honor.
Okay, I'm sorry. You got the IAN, so kind of
I know.
threw me off.
I get that all the time. You know.
I'm sorry.
Back in ancient days, Armenia was part of the Persian Empire, so we absorbed the name. But you know, I'm not going to get into history lessons. I'm not going to get into history lessons.
Well, unfortunately, I had a lot of history lessons because I worked for an Armenian family at one time. So, and they never let anything go.
They are close cousins. They're like the closest things to Persians other than Persians. Armenians are our cousins.
Well, thank you. And I have Isaac Sneed appearing on behalf of the people. This is a date and time set for arraignment in this matter. Mr. Kavajian, have you received a copy of the prosecutor's request for discovery, witness list, and felony information?
We have, Judge.
All right. And does your client wish to waive the reading of the felony information?
She would, Judge.
And how do you wish her to stand mute or enter a plea today?
Not guilty for today, and we will proceed forward with the prosecutor.
All right. So I am going to enter a plea of not guilty on her behalf. Mr. Kavajian, are you available for a pretrial on July 16 at 8:30 in the morning?
1 second, Your Honor.
And Ms. Adams, I'll need a notice of hearing from Ms. Hernandez.
You said July 16th, Judge?
16, 1-6.
I am wide open. We can do that on the 16th.
Okay. So we'll set this for July 16 at 8:30 in the morning, and that'll be via Zoom. Do you want to use Zoom?
Yeah, that's fine. That'd be better.
Okay, do you have my Zoom instructions?
Yep, I got it.
All right, excellent. And then Ms. Adams is going to get you a notice of hearing, and we'll mail a copy to you, sir. So you have a seat right behind us, and Ms. Adams will get you a notice and you go on your way.
Thank you.
So that way, if you're at work, you just need to take a break.
Yeah, that's awesome.
You know.
Thanks.
Okay, all right. So thank you, counsel, and you have a good day.
Thank you so much, Judge.
Thank you.
Take care.
All right. So you too. Thank you. Miss Underwood. I think she's with her.
Sorry.
Yeah. All right, Miss Underwood, let me get your people from the jail. Mr. Sneed, I believe Allison Arnold is on Israel Vila.
Hello.
I'm filling in for her, Your Honor. She's out today.
So I am ready for Israel Vila and I am ready for Angel Rosas.
Okay, we can get that around for you.
Awesome, thank you.
Yep, no problem. Bye.
Your Honor.
All right.
Okay.
Mr. Jones, do you know if Ms. Teskey's here today?
She's not in the office, but she's working today. Do we need to get in touch with her?
I sent her a message.
Okay.
Who's getting sworn in today? Is it an attorney?
Ileana.
Is she gonna be local?
I don't know.
Okay, Mr. Vila, hold on a second. Mr. Sneed, you're filling in for Allison Arnold?
That's correct, Your Honor. I believe the people wish to be heard on bond in this case.
Yeah, I also need Sarah Teskey. It was what I was looking for, but Mr. Jones might be able to fill in. So, Mr. Vila, I'm gonna grab your file.
I'm coming in, Your Honor.
You don't want to Zoom? Okay.
Hey, I got your text.
Okay,
I was just responding.
can you log on?
Yeah, I can log on.
Thank you.
Uh-huh.
Okay. All right, so hold on 1 second. Ms. Underwood, I called the jail for your other one too, all right? Okay, so I have Mr. Coast. All right. Okay, so this is in the matter of the people of the state of Michigan versus Israel Vila Jr., file number 25-22210FH. I have Rhonda Underwood appearing on behalf of Mr. Vila. I have Isaac Sneed appearing today on behalf of Mr. Vila for Miss Arnold. And I did have a meeting with Miss Arnold as well as Miss Underwood at Miss Underwood's request. Yes.
No, it
Yes.
wasn't at my request.
I don't know, somebody's, oh, it's my request.
Thank
And
you.
so I didn't have an opportunity to meet with them. I have Darren Coast appearing on behalf of pretrial services. Mr. Coast, do you have anything to report from Mr. Vila?
Well, Judge, as part of his bond, he is supposed to do 2 times a week drug testing. He hasn't done any tests since March the 17th. I know he's been incarcerated for some time. The last 2 tests that he did was back in March 10th and also March 17th, and he was positive for THC only on both. So I did talk with Miss Arnold yesterday. I know there's talk about him being released possibly to inpatient. Miss Arnold is against that, just because of his record and history.
Did you assess him at any time?
I did not, Judge, because typically that's done for the arraignment, but I can do that.
Okay, thank you. All right, so Miss Underwood, I think the plea offer that I had for both of you, well, I want to address that on the record.
No, Your Honor.
Miss Underwood, I have a plea offer in my file. Is there no plea offer?
That's the only plea offer.
So the plea offer was to plead to count 1, which is possession of methamphetamine with no drug sup and no supplements, correct?
Correct.
Okay, and then he's to plead in district court file number 25-0653FY. There would be a possession with intent to deliver with no sups and no drug sup, with a sentencing agreement of a kilobrew agreement between you and the people. Evidently, they offered a kilobrew to 51 months in the Michigan Department of Corrections concurrent. I'm just verifying for the record, Miss Underwood, if that was the plea offer that was made.
That is the plea offer.
And then Mr. Sneed, is that the plea offer that you show in your file?
Yes,
That's
Your
the
Honor.
one I wrote down. Okay, so the maximum penalty, were he to be convicted at trial, would be it's a third offense notice, so he'd be looking at a maximum penalty of up to 40 years in prison. But there's a drug sup, so that makes, so he could be facing a maximum penalty of up to 40 years in prison if he was convicted at trial. So, Miss Underwood, now you may proceed.
Okay, thank you, Your Honor. First of all, that plea offer has been relayed to Mr. Vila. He knows it backwards and forwards.
Yes.
Second of all, I would highly object to any change in the bond today, Your Honor, for one simple reason. Number one, first of all, the court was aware of this exact situation when Mr. Vila was last in court. There has been no significant change. None. Mr. Vila has been incarcerated.
Well, he's been incarcerated.
And so there has been no change since the last time Mr. Vila was in court and Ms. Arnold addressed these issues with him here. Second, Your Honor, I think we aren't asking for Mr. Vila to be out running the streets. No one's asking that. What the court, because there's a significant bond on the case downstairs, Your Honor. But what they are offering Mr. Vila, and the judge has already signed off on, is treatment where he goes, as I understand it, at 3 o'clock this afternoon.
So what's the offense date of the offense downstairs?
I'm sorry.
Was the offense downstairs committed while he was on bond on my file, Mr. Sneed?
Yeah.
So any sentence he gets on that one would stack on this one.
Right.
So he could serve up to 10 years minimum in prison and also another prison term on top of that, because he wouldn't get any credit. Okay. All right. So Ms. Underwood's correct. I mean, bond has never been addressed up here because he was in custody. So I didn't know he had a PR bond anyway. So his bond was set in district court on this file.
But you addressed bond when he was here the last time with Ms. Arnold. We had a whole conference about it, and then we addressed it on the record.
Maybe, I don't know.
And the court didn't change the bond.
Okay, so,
Angelo, can I say something before, before
no,
you?
no, not yet. It's not your turn to talk yet. So when I became aware that he was to be released to treatment, I requested a meeting with Allison Arnold from the prosecutor's office and you both came in to talk to me about it because the jail was asking me for permission to release him. That's why I set up the hearing. So, Mr. Sneed, you've heard the statement from Ms. Underwood. What is the position? Like right now, he has a PR bond on my file, but evidently your office is objecting and wanting that bond changed, which is why we're here. So it's kind of a reverse bond hearing. Usually it's Ms. Underwood requesting bond. So, Mr. Sneed, what are the people's position?
Your Honor, the people would request that the cash bond, in this case, be set at $50,000, which is what the district court file is as well. I think the court's well aware of our petition or our position regarding drug treatment. It appears the defendant's only tested positive for marijuana when he was tested. So if he had an issue with a more serious substance, it stands to reason he would have tested positive for it. And I don't think people go to rehab for marijuana these days. So we just asked the court to set the $50,000 bond in this case. And again, we would restate our position that there should not be a condition for release to rehab.
Evidently, that is a condition obviously out of district court. I think that people opposed it in district court and the district court judge did, that's my notes, agree to release.
That's correct, Your Honor, and we would ask the court to reconsider that.
Ms. Teskey, do we have a history with Mr. Vila of him being sent to treatment and entering? I don't have audio, Ms. Teskey. For some reason, I can't hear you. No, you're unmuted.
Can you hear me?
Yeah, I can hear you.
Okay. Your Honor, he was sent to residential treatment in the past and did not follow through or go to treatment. He absconded at that time. He absconded several times, but when afforded the opportunity to go to treatment in the past, he would abscond.
Has he done that more than one time?
Yes.
More than 2 times?
Your Honor, as a quick look on his prior case, he violated on 3 different occasions.
Mr. Coast, did we ever try to put Mr. Vila in treatment through pretrial services?
I don't believe so. Judge.
Okay. All right. And what is this treatment program, Ms. Underwood?
It's inpatient treatment. I'm sorry, I'm not cognizant of what it is. Okay. But here's what I would say, Your Honor. Mr. Vila has 40 years incentive to complete treatment.
But he's still not going to get a jail term.
Mr. Vila, this bond, Your Honor, this issue has already been addressed. If Mr. Vila does not.
What day did we address it? Because I can look that up.
The last pretrial. Ms. Arnold got up here and gave you chapter and verse, and the bond was not changed. You didn't add a rehab provision, but you didn't change the bond. There's been no material change.
So,
if
Ms. Underwood, what
does not comply and to the letter of the bond, I'm sure if he absconds, Ms. Arnold, I'm sure, will write the absconding charge in her sleep, Your Honor. And also the courthouse would not be deep enough for where there would be incentive to put Mr. Vila.
So Mr. Vila, at the very least, is facing 51 months in prison.
Right.
He's not facing a county jail term.
Right.
So
he has every incentive to get this right.
But it doesn't matter if he goes to rehab or not, because no matter what happens, it looks like he's going to prison.
We don't know that, Your Honor. That the case downstairs hasn't even went to a preliminary.
On this file, even if he takes the plea offer, he's looking at prison.
Right, but that's on the file downstairs.
No, this file.
That's well, if you want to send him to prison on his tenure.
No, I don't. I'm not saying I want to. I'm saying if he gets convicted at trial, he's looking at 40 years. If he takes the plea offer.
What's the worst thing that happened?
If
Mr. Vila gets sentenced to prison,
but if he takes
clean.
Stop. If he takes the plea offer, he's looking at 51 months. There's no county jail term here for him.
Right, correct. But what I'm saying is allow him, while these cases are going to.
All right, here's what I'm gonna say. Mr. Sneed, or Mr. Coast, what does your morning look like?
Judge, I have just a few more cases with you, but other than that, I mean, I could go over there this morning.
Do you think you could assess him this morning?
Absolutely.
All right, so I'm gonna have him assessed this morning by Mr. Sneed, and then I'll follow up with you guys at 1:30 today.
Your Honor, he's already been.
I said I'm having him assessed by Mr. Coast, and then I will follow up with you at 1:30. All right, Mr. Vila, we'll see you back at 1:30. Thank you. All right. Let's see. And then I have Angel Rosas at the jail, so she'll be zooming in. In the matter of the people of the state of Michigan versus Emmanuel Simmons, file number 24-22052 FH and 24-22051. This is the date and time set for a show cause against Mr. Simmons. The show cause is that he's failed to comply with bond conditions. Miss Adams, did we get a hold of Mr. Goldstein?
I have not tried yet, Judge. I'll do that right now.
This is bond conditions, and he does have an attorney. All right. All right, Ms. Rosas, can you hear me?
Yes, ma'am.
All right, this is in the matter of the people of the state of Michigan versus Angel Rosas, file number 25-22142 FH and 25-22281 FH. I have two files. I have one that is set for arraignment today, and that is file number 25-22281 FH. Miss Underwood, do you waive the reading of the felony information?
We do, Your Honor.
Have you received a copy of the prosecutor's request for discovery, witness list?
Yes, Your Honor. We would acknowledge the receipt. I'll be right in.
Would you need, wait, you're fine. She's gonna want to talk to you. Let me turn on
I don't
my
believe
thing.
so.
We're
Okay.
good. We're all set.
Hold on. Okay. I mean, all right, so do you waive the reading of the felony information, Miss Underwood?
I'm sorry, we do. We acknowledge its receipt and the receipt of the witness list.
Okay.
We would ask the court to enter a not guilty plea on Ms. Rosas' behalf.
Okay, so the court will enter a not guilty plea on her behalf and her bond's continued. So with regard to the pretrial, Ms. Underwood, on file number 25-22142 FH, are you on that file as well, Mr. Bandetto?
I am, Your Honor, yes.
How do you wish to proceed on that file?
Your Honor, I would present to the court a signed plea agreement by Ms. Rosas And also, if the court, Ms. Rosas did file some certificates of completion, Your Honor, but I believe I can submit those prior.
That can go to probation. Yep.
And I have, as you can see, I have reviewed that document in person with Ms. Rosas since she could not read it on the Zoom the last time, Your Honor. I believe she's already also signed a advice of rights.
Okay, so we will get that advice of rights from her. All right, so the plea agreement, as I see, is that, okay, that she will plead guilty on file number 25-22142FH to count 1 and count 5. She also has contempt of court and a bond violation.
Your Honor, on the contempt of court, Ms. Rosas will plead guilty to that.
Okay, that's the bond violation. Well, she failed to appear for pretrial on March 19.
Right.
That's a contempt of court. And then she has a bond violation because she was in contact with the alleged victim in this case, and that's the felonious assault charge that's being dismissed, right?
The plea will be delivered to a HIDA, Your Honor, and also the matter. Oh, and there is a restitution to the count to the city of Adrian of $900 some, Your Honor.
So is she pleading to the bond violation?
Yes, Ms. Rosas will plead to the bond violation.
All right, so she's gonna plead to the contempt of court, plead to the bond violation, plead guilty to count 1 and count 5. The other charges will be dismissed. The new felony file number will also be dismissed. But she will admit to count 2 in that new file?
She will admit only for the purposes of restitution.
Okay.
Your Honor. And this is a HIDA plea, and there is also a restitution on that issue is to be determined at a hearing if he submits any. And the restitution to the count to the city of Adrian, I believe it's listed.
It's $986.37. Right? Okay. Okay, so is restitution still to be determined on the new file though?
Correct.
Okay.
Yes, Your
So,
Honor.
Mr. Bayonetto, is that a correct recitation of all the pleas in this matter?
It is, Your Honor.
All right, so Ms. Rosas, you want to raise your right hand for me? The other right one. There you go.
Sorry.
It's okay. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, will you state your full name for the record, please?
Angel Marie Rosa.
Okay, good. All right, so you can put your hand down. Let me get rid of these other jail rooms real quick. All right, so Ms. Rosas, you have heard the statement of your attorney. Is it your intention to plead guilty on file number 25-22142FH to count 1, malicious destruction of fire or police property, which carries a maximum penalty of up to 4 years in prison, and count 5, domestic violence, which carries a maximum penalty of up to 93 days in jail?
Yes, ma'am.
Okay, and and there's no sentencing agreement in terms of what happens at sentencing, is that correct?
HIDA, Your Honor.
Other, but jail
Outside of
term,
I don't believe there would be. I'm
asking if there's any agreement between you and the prosecutor as whether there be no upfront jail or anything like that. I don't see it.
I would hope that would be the case, Your Honor.
No, I'm asking if it's in the agreement. I don't see it in the agreement. So Mr. Bayonetto, there's no agreement as to whether or not there would be a jail term at the time of sentencing, correct?
Correct, Your Honor.
Okay, That's all I was asking, because I don't see anything in there. But, Ms. Rosas, do you understand if you're eligible, you could be sentenced under the Homes Youthful Training Act, which means basically you're grounded for the next 2 years. And you have to do everything I say and honor all the probation terms and not get in trouble. And then these would never go on your permanent record. Do you understand that?
Yes, ma'am.
Okay. Are you satisfied with your attorney and the advice that she has given you?
Yes, ma'am.
And then do you understand on the new file, for purposes of restitution, you would have to admit that there was destruction of some property in that file, and that you're also pay restitution in that one as well. Do you understand that?
Yes, ma'am.
All right. Now, we talked about whether or not there'd be jail. There's no agreement regarding that, but the maximum penalty could be up to 4 years in prison. That's not going to happen, but do you understand that's the maximum penalty?
Yes, ma'am.
Okay. Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Ms. Underwood?
It is, Your Honor.
Is that correct, Mr. Bayonetto?
That's correct, Your Honor.
And Ms. Rosas, is that correct as far as you're aware?
Yes, ma'am.
All right. If a guilty plea is accepted, there will be no trial. Can you hear me? Are you having a hard time hearing me?
Yeah.
Okay. Do you have a hard time hearing to begin with?
Yes, ma'am. But I can read your lips a little bit.
So I'm going to ask you to knock on the door. We have closed captioning available, and you just need to turn that on your device. So let's see if someone will come in.
I can't hear them.
Just. So do you know how to turn the closed captioning on? I'm going to tell you if you don't.
Well, I do not. If you could let me know.
Okay, go down to the bottom of the screen and you see those 3 dots that says more?
I do.
Is there an icon?
Oh, yep, I
for
see
caption?
it.
Okay.
All right, they're on.
Okay, excellent. Thank you. All right. So, Ms. Rosas, you should start to see words streaming.
Yes, ma'am.
Okay, and you can read, correct?
Yes, ma'am.
Okay, excellent. So, are you satisfied? So I'm going to start back a little bit just to make sure that you got everything. So you heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 1, malicious destruction of fire or police property, which could carry a maximum penalty of up to 4 years in prison, as well as count 5, domestic violence, which carries a maximum penalty of up to 93 days in jail? So is it your intention to plead to those 2 counts?
Yes, ma'am.
Now, on the other file, there's a malicious destruction of property, and you're going to admit that for purposes of restitution. Do you understand that?
Yes, ma'am.
And the restitution in this file is $936 on the file we're pleading to is $936 or $986.37 payable to the Adrian Police Department. Do you understand that?
Yes, ma'am.
And the restitution on the file that's being dismissed has not been determined yet. Do you understand that?
Yes, ma'am. Now, would I have time to find like a job or something before I?
Oh, yeah, you'll have a couple years probation to pay that off, okay?
Okay.
And then the other agreement is that if you're eligible, which I assume you are, your attorney wouldn't have done this, you will, if you are sentenced under the Homes Youthful Training Act and you're eligible, that means for 2 years, I'll put restrictions in place, like a curfew and no alcohol, and you'll basically be grounded for, 2 years. Do you understand that?
Yes, ma'am.
And then if you successfully complete that, these offenses will come off your record. Do you understand?
Yes, ma'am.
Okay, do you have any questions about what you're pleading to today?
No, ma'am, just a question if I'm getting out or not.
Well, we haven't gotten that far yet, so we'll address that. So are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes, ma'am.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Underwood?
It is, Your Honor.
And Mr. Bandetto?
Yes, Your Honor.
And how about you, Ms. Rosas? Is that correct as far as you're aware?
Yes, ma'am.
If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
Now, this is important because your attorney may be addressing bonds, so I want to make sure you understand this part of it. Do you understand that if your plea is accepted and you engage in any misconduct between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating your terms of conditions on bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. So basically what that means is if you violate your bond conditions, then I'm free to sentence you however I want. You may not be eligible for HIDA. Do you understand that?
Yes, ma'am.
Okay. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, ma'am.
All right. So, Ms. Rosas, how do you wish to plead to the charge that on January 3rd of 2025 in the city of Adrian in the county of Lenawee, that you did commit the offense under count 1, malicious destruction of fire or police property? Guilty or not guilty?
Guilty.
All right. And how do you wish to plead to the charge that on that same date and time and venue that you did commit the offense of domestic violence in count 5? Guilty or not guilty?
Not guilty.
Are you pleading guilty to domestic violence? You're pleading guilty to count
Oh,
1?
yeah, sorry.
Okay.
Yes, ma'am.
So how do you plead to count 5 domestic violence?
Guilty.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to these charges other than what we've talked about on the record?
No, ma'am.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood?
No, Your Honor.
And Mr. Bayonetto?
No, Your Honor.
All right. Ms. Rosas, has your attorney promised you any particular sentence or estimated what your sentence will be in terms of probation, fines and costs, or anything else?
No, ma'am.
Is it your own choice to plead guilty?
Yes, ma'am.
All right. So Ms. Rosas, on January 3rd of 2025, we're in the city of Adrian in the county of Lenawee?
Yes, ma'am.
Okay. So at some point, you came in contact with an Adrian police car, is that correct?
Yes, ma'am.
And did you destroy it or damage that Adrian police car?
Yes, ma'am.
What did you do?
I broke the handle bars off the doors. On both sides. And I don't remember what else, but I was kind of blacking out at the same time.
Okay. Are you satisfied, Mr. Bayonetto?
Yes, Your Honor.
All right. And then, were you in the company of the Miguel Rivera?
Yes, ma'am.
And was it your boyfriend, a sibling? Who is he to you?
An ex-boyfriend.
Okay. And you also injured or damaged him as well?
Yes, ma'am.
What did you do to him?
We were fighting, but he didn't go to the hospital or anything like that. Only I
What
have.
did you do? Did you kick him, punch him, knee him?
I punched him, I choked him.
Okay. Okay. Are you satisfied, Mr. Bayonetto?
Yes, Your Honor.
All right. Has the court complied with MCR 6.302 B, C, and D? Ms. Underwood?
It has, Your Honor.
Mr. Bayonetto?
It has, Your Honor.
Okay, so now I'm gonna pause and I'm gonna grab your other file. So Ms. Rose says you're obviously not pleading guilty on this file, but on May 9th of 25, we're in the city of Adrian in the county of Lenawee.
Yes, ma'am.
And did you destroy a cell phone, a fish tank, a fish, which belonged to Miguel Rivera?
Yes, ma'am.
Okay, you understand that you're gonna be responsible for restitution on that, and it will be somewhere, is it somewhere between 200 and 1,000, I'm assuming, Mr. Bayonetto?
I would guess, Your Honor, that would be the case.
Okay, all right. I accept the plea. It's been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. I am going to set sentencing for July 16 at 8:30 in the morning. Are you available that day?
That's fine.
Yes.
All right. So before we proceed any further, are you addressing bond?
Yes.
All right. So go ahead and address bond.
Your Honor, Ms. Rosas has been in jail since May 9th. Ms. Rosas understands at this point, and I think has come to the brutal reality that this is just a toxic relationship and they cannot be around each other. She knows that. The last thing she's gonna do is go back to Mr. Rivera. When he is not involved, Your Honor, Ms. Rosas is not a violent person. She's not. I think it's a domestic situation that goes both ways. It's toxic. Ms. Rosas has used her time in jail wisely. She's completed parenting while incarcerated, anger management, and houses of healing. I know Ms. Rosas is going to reach out to Catherine Cobb, Your Honor, at this point. I think she's got a hefty restitution to pay. I think it would only benefit everyone, including Ms. Rosas, to, while she's awaiting sentencing, to let her out, let her get a job, housing, and stabilize herself, Your Honor. Because as soon as she does that, the better.
All right. Mr. Bayonetto, does Ms. Rosas have a prior record? Or Mr. Coast, have you evaluated her?
I did, Judge. On June 2nd, I did speak with her over at the jail. Did a pretrial assessment. She did score a 5 on the assessment, which puts her in the moderate range to be rearrested while on a bond or not appear for future court dates. She scored points to where she has the one failure to appear. She also wasn't working and doesn't have stable residence. The good thing is, though, she does lack a criminal history, and she does not have any substance abuse problems.
All right, so we have no substance abuse, no prior record. She doesn't have housing stability, but Catherine Cobb and other places are available, and we have other people out on bond at those facilities. So Mr. Bayonetto, obviously, if she fails to appear for sentencing, she could now have all her charges reinstated, plus another charge of absconding and end up in prison. So Mr. Bayonetto, what are the people's position?
I have no position, Your Honor. I would defer to the court's discretion.
So, Ms. Rosas, I am going to give you a bond today, but I'm putting bond conditions in place. Do you understand?
Yes, ma'am.
If you don't follow them, I'll issue a bench warrant for you, and then your plea bargain will go away. So it's very important that you follow these bond conditions. Do you understand?
Yes, ma'am.
So I
Thank
am
you.
going to require you to report to Mr. Coast once a week. Okay? You're not to
Yes, ma'am.
use any illegal, okay, not to use any illegal controlled substances or consume any alcohol, and not to commit any new crimes. Do you understand that?
Yes, ma'am.
There is a no contact with Miguel Rivera, so you are not to be on his block, in his neighborhood, where he works, nothing. I don't want you to even, if you see him, you run the other way. Do you understand?
Yes, ma'am.
All right, and Mr. Coast will make arrangements with you on how to do that. So, do you have any questions about that?
No, ma'am.
All right, and
should she report to?
Hold on, I'm gonna get there. Let me do this. All right, Mr. Jones, I'm gonna put you in a breakout room with her today real quick, but do you want her to report to the courthouse today when she gets out?
Yeah, actually, Judge, I won't need to be in a breakout one. Just she needs to report to
Okay.
our office upon release.
All right, so Ms. Rosas, I'm gonna release you from jail today on a PR bond with those bond conditions. When you
Yes,
get out
ma'am.
of the jail, you're gonna walk across the parking lot to the courthouse and you're gonna take the elevator up to the 3rd floor. We go
Yes,
to
ma'am.
lunch from like 12 to 1:30. So if you come over, just wait for us to reopen. Mr. Coast, you're gonna wanna see Darren Coast, who you just asked for at the clerk's office across the hall from the elevator. And then you're gonna walk down the hall to the probation department on the 3rd floor and get your information from them, okay?
Yes, ma'am.
I'm gonna set sentencing in person July 16 at 8:15 in the morning, just, what?
Would that be July 18th?
Oh, well, I've been telling
I'm sorry.
everybody July 16 today, so we gotta fix that. Or maybe I haven't. So July 18 at 8:15 in the morning. Ms. Rose says, I'll make it in person because you are not stable right now, so it'll be easier for you to come in person. When you
Yes,
meet
ma'am.
with the probation department, they're gonna give you a time to come back and talk with them. Make sure you come in and talk to them, all right?
Yes, ma'am. Thank
I'm
you.
gonna have Mr. Coase have you sign an advice of rights form for us too, that goes over the rights that we've just done. Do you have it? Oh, I already got it. Never mind. Make sure you see Mr. Coast and the probation department. When you meet with the probation department, be truthful about your background and the events that occurred. They'll prepare a report. I'll provide it to Miss Underwood. And about a week before sentencing, you go see Miss Underwood to review that, all right?
Yes, ma'am.
Your paperwork from the jail will have your sentencing date on it, so don't lose that paperwork, all right?
Yes, ma'am, I will.
All right, so you're gonna get out of jail, you're gonna come see Mr. Coast, you're gonna come see the probation department, and we'll see you back for sentencing on July 18 at 8:15 in the morning. Ms. Rosas, remember, don't get in trouble, okay?
Yes, ma'am. I won't.
All right.
I won't mess it
Thank
up
you
this
so-
time.
All right, thank you. Anything else,
Thank you.
Mr.? No. All right, I
Thank you,
do
Judge.
believe that does conclude our docket. I don't know where Mr. Goldstein is, so we'll adjourn that with his schedule.
He's in the district court.
Well, I'm done. So we'll just adjourn it. All right, that concludes our criminal docket for the morning. Thank you.
Can I just ask,
Oh, never mind. Hold on. Chris Jones, don't go anywhere. Rhonda, can I see Mr. Goldstein real quick? I have to leave. So I want to see Mr. Goldstein. Give me 1 second. What was your question?
Jacinto Rodriguez, I discussed his extradition with.
He already waived it. We're done. Okay. All right, Mr. Goldstein, you are always here. Mr. Simmons is always usually here. So in the matter of the people of the state of Michigan versus Emmanuel Simmons, file number 24-22051 FH, 24-22052 FH. Mr. Goldstein, a motion affidavit in order to show cause was mailed out on May 16th to your client and hopefully you. He was testing positive for OxyContin and cocaine on April 29 of 25, tested positive on May 4 of 25, and then noroxicodone also and cocaine. So we sent a show cause to him. He did not appear today. Have you heard from him?
Judge, I knew nothing about it. I just happened to be in the building.
Do you want me to reschedule this?
Please, Your Honor. I mean, I'll get a hold of it and find out, but if I could have a copy of whatever was filed.
Yeah, we can get you a copy. When are you, like, do you have a date you're gonna be here already?
Your Honor, as you noticed, I'm not coming to Adrian very often anymore.
I know, and we greatly miss you. I don't like it.
But as long as I can do this by Zoom, next Wednesday looks good, Your Honor, the 11th.
The 11th? Miss Adams, I have the book.
And if she can just email me a copy of whatever was filed,
I can get you a copy today or email it. Okay, I'll set it for, I do have, fine. We'll do July 11th at 8:30 in the morning. You're always here.
Yes.
So I'll do July 11 at 8:30 in the morning and we'll give you notice of it and then we're good.
Thank you, Your Honor.
All right, thank you, Mr. Goldstein. And that concludes our criminal